Welcome to the Triple D Podcast, Donuts, Disability, and Discourse, where host Michael Leiner talks to the best in the business about community, impact, business, and donuts. Here's your host, Michael Leiner.
Welcome to another episode of the Triple D Podcast. I have a great guest this week, Kristin Roberts. You want to introduce yourself, Kristin?
Kristin Roberts. I have a firm in Independence called Kampinski & Roberts, and we specialize in interesting cases. So we do litigation, mostly ends up being medical malpractice or catastrophic injuries that are not as a result of medical malpractice. But we do any kind of litigation that interests us, that's interesting.
I love the way that you preface that, because most people just launch into, I'm a medical malpractice attorney or I'm a car accident attorney, but you practice law that interests you.
Yes.
Is the way that you say it. So and that can be a variety of things. So how do you decide what interests you? Yeah, go ahead.
Just a case that just has an interesting story to it and that we can help people with. So anything that interests us as far as the story, that we can take it to a jury and make them understand how it came to be and what was done wrong. And, it can be a variety of topics. So we take that topic and we learn it as well as, the experts in the case, and we make a jury understand.
It's interesting that you say that when you're thinking about case selection, what interests you, you're already thinking about a jury. But tell me if I'm wrong. Don't so few, everybody imagines that when they hire a lawyer, they're going to have a trial, a month-long trial with a judge, but most cases don't make it that far, right?
So that's something that we do, and maybe not, but I think a little different than a lot of firms, which is we never take a case to settle it, for one. We take a case because we assume we're going to go to a jury. So when we start a case, we start out getting ready for trial. So we do interrogatories to the jury, things like that, where it takes us down a path to get ready for it. The more ready that you are, the more chance you have of resolving the case early, because you're always looking for that one thing that's going to really resonate with the jury.
And so, I don't know if you've read this book. It's one of John Morgan's books, but in it have you read any of John Morgan's books?
I have not.
Okay, I'm trying to remember the specific name of it's his first book that he wrote. But in it, he and I think so many injury firms, they take cases expecting settlement. And to kind of combat that, he has a rule that every lawyer in his firm has to have at least one jury trial a year. How many of your cases, percentage-wise, do end up making it as far as a jury?
Not many.
Okay.
And I think part of that is because the defendants know that we're ready to go to trial from the beginning. So they know that once we go to trial, we're going to be so ready that they can't really hide much.
And that helps you get what you're asking for without the fight?
Exactly.
Yeah. And you just had a pretty big jury verdict recently, didn't you?
Yes.
Are you able to talk about that?
Yes, absolutely. It went to verdict, so everything is public. It was $7.625 is the amount.
$7.62?
No, $7 million.
And was that like the biggest jury verdict that you've ever had?
No,
personally?
The largest was $27 million.
Wow.
And then we had 19.9. That was a settlement.
And what's it like? So, when I do a Social Security disability case, the way that we have everything set up in our office, and it's for the benefit of the client, it actually improves the product that we're delivering to our clients as opposed to cheapening it, is everything's pretty much on an assembly line. We've got specialists that come in and, they handle a certain element of the case, And an attorney really is only there at the very tail end to get the client across the finish line after a hearing. But I imagine when you're working on cases that are worth 19 million, 27 million, 7.625 million, I mean, you can't have an assembly line. You've got to be learning new things and refocusing. What's the process like of putting a case together?
So from the very beginning, we start asking for tons and tons of discovery, and we learn as much as we can about the case, the people in the case. We never stop digging. We leave no rock unturned. We review things that we've looked at 100 times, 100 more times, because as you go through the process, you learn more and more and things become relevant. And every time you go through the record, you learn something new. We think about our cases 24/7. I mean, my partner and I do things very similar, but we'll keep, a notepad by the bed. We'll wake up and have an epiphany, but we always look for things that other people may not look for. We have active imaginations, so we always try and find the things that most lawyers don't look for because they can't imagine exist. My partner had a case in the early 80s, and it made the law for spoliation of evidence for an altered record. And we have had so many cases with altered records and things that are hidden, and those things really help the case to get resolved. And if it does go to a jury, the jury gets mad because you expect your doctor to be, helping you, not trying to hide records and change records and things like that.
So like the most recent big verdict that you had, that you mentioned, like, as much as you can, like, tell us a little bit about what happens so people can understand what happens that you're working on.
Sure. This is a woman who was more active than anyone that I've ever known. She used to be a competitive swimmer. She was a horse trainer. She was also a special education teacher. But she and her husband hiked the mountains the treacherous mountains. She would bike across states. She was just extremely, extremely active. And she had a surgery a number of years ago on her back. And she got an infection after that surgery. The infection caused what's called arachnoiditis, which is an inflammation and a scarring of the layer of your spinal cord. What that causes is the cerebral spinal fluid, or the CSF, to not be able to exit. So it can't just stay in there because you make about a cup and a half a day in your brain of this spinal fluid. So it caused pockets of fluid, which are called a syrinx, in the center of her spinal cord. So it was causing her some pain. But she was still doing all of the things that she always did. She was still, extremely active, but she had some pain. Everybody, has some pain here and there. So she sought help for that pain. And she went to the Cleveland Clinic, and there was a doctor there who was actually at one time the head of neurosurgery. And he said, "I can fix this. No problem. You will be 95% chance you will be cured of your pain, and 100%. 5% chance there'll be no change."
So up until this point, though, she's active, she has this terrible injury. There's no errors here. This is just an unfortunate circumstance.
Right.
So far.
She didn't have a terrible injury. She just was unfortunate to get an infection.
Right.
So,
right.
And now this was many, many years ago. So she had lived with this for a very long time.
Oh, okay.
So the downside, if you can call it that, is that she would be the same, per the doctor. So she said, well, there's no risk. This is great. Of course I'm going to do the surgery. So she actually went on a big vacation where she hiked the mountains in Acadia National Park and everything before the surgery. So
she was good.
So she was good. had she been told that there's any risk of anything, she wouldn't have done it because she could just, take some Tylenol and go on with her life. So she goes to have the surgery and she wakes up paralyzed. She can't move her legs, and she's in horrific pain. And typically what's done at that point is an MRI to see what happened, because you have a certain amount of time, a very finite amount of time, usually around 24 hours. Some people say that it could be 48 hours, but time is of the essence. So you want to see what just happened and can we undo it? Because you can, if it's something that can be undone, you can go back in, fix the problem. Well, they didn't do an MRI. The head surgeon left and went to a conference in Houston, left his resident to deal with it, who had never done this surgery before. And not only did they not do an MRI, they put an order in her chart that no MRI should be done. So when the night resident came on, the first thing he would say is, "Oh my gosh, this lady's paralyzed. I need to do an MRI." But there was a note that said, "Do not do an MRI."
Did it ever come out why that note would have been placed in there? Was it a mistake or was it intentional?
Well, it never did come out why that note was placed in there. The defendants claimed that they wanted to reduce the stress of the night resident.
Wow.
So I'm sure that's not why. But
it's amazing that they would even go on record and saying that.
Well, they also said that the risk of doing an MRI was falling off the gurney.
Wow. Okay.
Yeah. So she's in the hospital for about a week. She never gets any better. She goes to rehab, a Cleveland Clinic rehab, and she's never gets any better. Months go by. She's still no better. She's still paralyzed. She's still in all this pain. Finally, an MRI is done, and she goes back into the doctor, and he says, "Oh, you have a new syrinx, and I can fix it, and we're going to do another surgery." So she says, "Good, okay, fix it, because, this is unbelievably awful." So she goes into surgery, and she comes out, not only is she not fixed, but she is in worse pain. So at that point, the doctor pretty much washed his hands of her, said, "I can't do anything for you." And they tried to put a pain pump in her, things like that. Nothing really helped. So we didn't know in the beginning of the litigation what happened. We thought that he did the wrong surgery, and he did do the wrong surgery. So basically, he put a shunt in, which is a tube that carries the fluid, but he put the shunt from the middle of the spinal cord to where it came from. So the spinal fluid still couldn't get out. And he says, "Oh, I do the surgery the same every time." Well, the etiology for this issue was that it couldn't get out of this layer of the spinal cord. So he put it right back where it was, so it just kept circling around where it was. We had a textbook that was, they call it the Bible of Neurosurgery. All neurosurgeons use it. They teach their residents on it. It says you cannot do this procedure in the face of infectious arachnoiditis, which is what she had. When I say, we do research, we never stop doing the research, because if you can find something like that, that's pretty good. So our expert looked at the films, and he said, "Oh my gosh, there is something in here," because we couldn't figure out why they were doing the second surgery, because on the films there's no new syrinx. There's just no new syrinx, And you can't fix the paralysis. She's after that 24-hour whatever period, you can't fix it. It's permanent. So we were trying to figure out why did he do the surgery. So our expert told us that there's something in there, and I think it is what's called a surgifoam or gel foam sponge, which is supposed to be put in a very small layer if you use it to stop the bleeding on the spinal cord, and then remove it. But now the surgeon left. He left before she was closed up. So this resident who had never done this surgery before was left to close. So we alleged that, from what our expert told us, that this sponge was too big and left in there. It can't dissolve when it's up against a laminectomy site, so because that's bone, the lamina. So magically, after they did the second surgery, it's gone. So why did they do the surgery in the first place? They couldn't fix the paralysis. He knew that. And it just made her worse.
They did it to cover up the mistake that they made the first time.
That's what we alleged.
And the jury agreed with you.
The jury did not find the sponge specifically, but they found that it was negligent to do the MRI, and it was negligent not to put a note in the chart not to do the MRI, and they did not comment on the sponge, but we can't think of another reason that he went back in and did another surgery.
So let me ask you, doctor works for the Cleveland Clinic. Sounds like it's, at least the first doctor is a big time, you said, former chief of neurosurgery.
Yes.
Cleveland Clinic. You must have a big reputation and have done good work to lead up to that. First of all, you're suing the Cleveland Clinic, right? The doctor doesn't get sued personally.
Correct.
Okay.
You can sue the doctor personally, but they like to take responsibility for the doctors. And
what happens to the doctor?
Nothing.
So if I had a family member who was injured or needed a surgery today, that doctor could be the doctor who is performing a surgery.
He's still there. Yep.
There's no disciplinary action. There's nothing that happens.
Not typically. It's very far and few between that anything happens to the doctor.
So about it's 2023. This was in 2012. My dad noticed that he was having some irregular feeling in his tongue. Okay. And he had a doctor who was at least concerned enough that after a period of time they ordered a PET scan, and they told my dad that the PET scan came back negative, clean. There was nothing there. Still was bad. He wasn't, feeling his normal self. Maybe it was another 6 or 8 months later until he goes and has another PET scan, and sure enough, they find that there's cancer. But then when he was, moved over to oncology and they're reviewing everything, including that first PET scan, they look at it and they say, I don't get it. How come they didn't start treating right away? Because the cancer had been there all along. Same story. Nothing happens to the doctor. How is that allowed to continue?
That's a very good question, and one that I can't answer. We have had cases where the doctors have been fired. Like I say, it's not often, but we have had cases where we have tried to make that a condition of the settlement, or negotiations, because a lot of times that's what our client wants is. They don't want this to happen to someone else.
Right.
But really, all we can do is get them money I mean, that's really, we've had cases where we've gotten drugs that are expensive drugs kept in, emergency rooms, so that, someone doesn't die again from like
Yeah.
what we've sued for. But typically, all we can do is get them money.
I feel like sort of a conflict as a professional with a professional responsibility to clients, like when I'm out there saying somebody should be punished for this.
Yeah.
Because, I don't think any of us can ever say that we're perfect. I do the best that I can every single day for my clients. I know you do too. But there's always intangibles floating around that make it impossible to be perfect every single day. So to say like that person should lose their license because of one bad accident, what about the 1,500 successful surgeries they did that positively altered somebody's life? Do you ever think about that or feel that?
I do, and I think that, everybody makes mistakes.
Yeah.
And obviously doctors and lawyers should be held to higher standards than they are. But I think in the circumstances where they do get fired or something, disciplinary action is taken, it's usually because they want to step further. It's usually when they alter their records, they hide records, they, do something like that.
So it was going in, even if that's not what necessarily convinced the jury, the sponge, but it was something off about that second surgery, which didn't really have much of a chance of doing anything that you think makes you think, whoa, this is really offbeat.
Yeah.
Yeah. So we kind of got to the finish line. You presented the facts of this. Tell us what it's like. So this person comes to your office and they tell you about this terrible thing that's happened to them. What do you, when you're sitting here telling me about this, you sound like a doctor. So, how do you approach it? What do you start doing?
Learn everything you can about the injury, about, the anatomy that you're dealing with. I learn as much as I can about it before I even engage an expert.
Yeah.
Once I've done that, I feel like I need to have a very good understanding of what is going on before I even talk to the expert, because I need to be able to ask questions and, respond to what he's telling me. From there, once we know that we have a case, we talk to the expert throughout, and we learn the medicine inside and out, backwards and forwards, because when we take a deposition, the doctors love to try and just completely bullshit you in a deposition, because that's what they do. They're experts on this. So if you don't know the medicine, now you can't beat them in the medicine, but if you know enough to know that they're full of crap and you get them, they kind of back off, and it's very helpful, I think.
Yeah. How long did it take to resolve that case?
Let's see. It was about 4 years.
4 years. So it's a long process.
Yeah, at
And-
least 4 years.
And while that's going on, doesn't sound like there ever could be, but has there been any change in the health of your client?
No.
And there won't be.
There won't be. No.
Yeah. So you said something that was so interesting to me before we even started talking about the specifics of this case, which is you keep a pad of paper and your partner keeps a pad of paper next to his bed and you keep one next to your bed, and you guys are just always thinking about these cases. When you think about the personality traits that you have, which you may have had your whole life, but you never really knew where they were going to manifest or how you'd use them. Obviously a curiosity and just tenacity to always keep thinking about it and going for it. But what other traits do you think make you good at what you do and separate you so that your office can go and get these, multiple $10 million plus verdicts or settlements for people? What are the personality traits that make a lawyer great?
Working hard and never giving up, and never, just using your curiosity and your imagination to just dig deeper and deeper and leave no rock unturned. And even when there's a small chance that there's something there, you just kind of have to look everywhere.
Yeah.
and find it. And we had a case where there was an ablation procedure,
Uh-huh.
a heart ablation, and something was really bothering me about it. And we had an expert, and he was okay, but something was bothering me. There was something more there. So I looked up and I found an expert who specialized in the mapping, taught the mapping. So when you do an ablation, there's a mapping person
Sure.
and a map of the whole heart, and they map out everything they're doing. So he specialized in that, and he called us and said, are you sitting down? Are you ready to talk about this? Because I found something. So what happened was the doctor, after the procedure went wrong, went in with the mapping technician and deleted the points, the relevant points, deleted points, and then added points, and wrote his note off of the point that he added and said, we were this far away, so I don't know how this happened, and embellished on this. And so that's what he found. There was actually a delete bin that we would have never known. And, most of those kinds of doctors, electrophysiologists, they don't know that either because they're not specialists in the mapping
Right.
technology. So that was pretty helpful. That one settled.
Yeah. So, especially these big cases where they involve, significant misconduct and usually somebody's trying to hide something or cover up. Let's talk about this from the other perspective. I mean, you must look at a ton of cases or potential cases where somebody calls in, something terrible happened to them, and you find that nothing was wrong. I mean, at least nobody did anything wrong. It's just an
Yes.
unfortunate circumstance.
Yes.
How much of the time do you look at a case and you see there was something so egregious like your recent verdict, or you look and you're like, no, the doctor did everything they could or they were supposed to do?
It definitely happens. And I think that, it kind of gives the family a peace of mind. At the end of the day, you can't help them, but you can at least tell them, look, we looked into this so far, and there is just nothing that could have been done. This was either a risk that happens. They took all the precautions they could. They did everything they could to save your loved one. And, sometimes that's all the family needs. They don't, they don't necessarily want something to be done wrong, but it happens. And I don't know really a percentage, but I don't know, maybe 25% of the time,
25% of the
That's
time
what
there
I-
was nothing that was
Yeah.
wrong? And is this like 25% of the people who just initially call your office and say, hey, I think I have a case?
So we take about, and this is even probably high, but I'm going to say about 1 out of every 100 cases that we look at. And
That's what I would think.
yeah,
Yeah.
normally we can tell from the story that we're told, whether we can help or not. And
Yeah.
that's the criteria. It's very simple. Can we help them? And, if it's a risk of the procedure, there's usually not a case. So, sometimes it takes a little bit of research, but a lot of times we can just tell just from what they're telling us.
Yeah. Well, thank you so much for coming and sitting with me and sharing about what you do and hearing about how a case is put together. It's nice for me to be able to talk to somebody who's, actively litigating like you are. But we do have a tradition on this show. We usually have it at a donut shop, but we're here at Davis Bakery in Woodmere, which doesn't have donuts, but they do have a delicious concoction here. I'm presuming it's delicious. It looks good, right?
What's it called?
It's called a radio bar. A radio bar. And you and I are going to try this together. What do you say?
Sounds good.
I'm going to cut a piece there for you. I'm going to cut a piece for myself, and we'll sample this together. What do you say?
All right.
Let's go for it. A little bit messy here. Probably not intended to be eaten with your hands, but
No.
they do have a sink we can use after. So, that is sweet. delicious coconut flavor. I like that.
Good thing I like frosting.
If I like frosting, this is a good dessert. This is a great dessert. Well, thank you so much, Kristin, for being here. And we wish you so many more big verdicts from helping people that need it in the future.
Thank you.
Thanks for listening to the Triple D Podcast, Donuts, Disability, and Discourse. Rate, subscribe, and tune in next week for more discourse and donuts.